I'm here now to talk to you in this entry about a special type of petition or lawsuit that's filed in the state of Texas. It's called a Petition to Investigate, or a petition to take a deposition. It's not really a lawsuit because the people aren't being sued. What it is, it's a lawsuit under Texas Rule of Civil Procedure 202, in which the other side is trying to get information from you and trying to find out whether or not you have information that may provide them with enough to go forward and file a lawsuit against you. Rule 202 says that they can go ahead and take a deposition in the case, and they can go ahead and get some limited documents from you. If you have a Rule 202 petition filed against you, courts routinely allow that. They allow people to go forward and investigate a claim before they file a lawsuit. That is because when a lawyer files a lawsuit and signs off on the lawsuit, they're saying that the lawsuit's being brought in good faith and that the lawsuit is not groundless. In other words, you can't file a bad faith lawsuit, you can't file a groundless lawsuit. And so to avoid that, and most times lawyers are doing it for good reasons, they go ahead and try and find out the information before the lawsuit is filed. Under a Rule 202, the court has to have a hearing before they'll allow the deposition. They have to have a hearing before they'll allow the documents to be obtained. Those hearings, what happens in those hearings is routinely courts will limit the depositions, they'll limit the scope, they'll limit the time, and sometimes they'll limit the document requests to make them more reasonable. But most of the time the courts will grant it. Recently, our law firm was involved in a case where a lady came to us and she had a Rule 202 petition filed against her. She had a non-compete agreement, and the other side was trying to find information to see whether or not she was violating the non-compete agreement. We had the hearing, we went in front of the judge, and our argument was that the non-compete agreement would never be enforceable. The non-compete agreement had problems with the geographical restrictions. In other words, it was too broad. And we argued that because it was so broad, the non-compete could never be enforced, she could never be properly sued, and therefore there was no reason to have the Rule 202 deposition. We were very fortunate that the court denied their motion for the Rule 202 petition, and it can't go forward. Now, of course, the other side has the opportunity to file suit in that case, and so the case may not be over, but we were happy with the court's result, the judge's ruling, because now our client doesn't unnecessarily have to go through a deposition, doesn't have to unnecessarily go through and find documents. If you are seeking a Rule 202 deposition, or you're seeking some information from someone you're not sure you're going to sue, or if you've been sued under Rule 202 and you'd like some advice, feel free to give us a call. Let's see if we can help you out. Thanks.